The United States Supreme Court released its ruling in the case Loper-Bright Enterprises v. Raimondo. The Supreme Court, in a 6-3 decision, ruled in favor of the petitioner, Loper-Bright Enterprises, which is a New Jersey-based herring fishing company. The decision, at least in theory, will significantly reduce the power of the executive branch of the U.S. federal government and increase the power of the judicial branch. At least that is the position of the government supporters. Like so many things in Washington, the ruling is being viewed through an ideological lens as a win for the right and a loss for the left. However, this perspective misrepresents the true nature of the ruling, which is a win for supporters of the democratic process, as it restores the balance of government power and, more importantly, returns power to the citizens of the United States. Loper Enterprises brought the case against Gina Raimondo, the U.S. Secretary of Commerce. The case stemmed from the 1976 Magnuson-Stevens Fishery Conservation and Management Act, which created the National Marine Fisheries Service under the Department of Commerce. The case revolved around the law's requirement to place federal monitors on fishing boats to ensure compliance with the law and prevent overfishing. The law was vague in regard to the funding of these monitors in the Atlantic fisheries. Secretary Wilbur Ross led the Trump administration's Department of Commerce in enacting a rule requiring fishing boats to pay a $700 fee for the required monitor, a steep cost for small business operations that ultimately resulted in a filing in the U.S. federal court. In an attempt to preserve executive branch authority, President Biden's administration decided to defend this case from the previous administration. This case revolved around the accumulation and preservation of executive power at the expense of the legislature's authority and responsibilities. Under the doctrine called Chevron Deference, the Department of Commerce received the authority to interpret the vagueness of the law. In 1984, under the Reagan administration, Chevron v. Natural Resources Defense Council was a case over an interpretation of a law by the Environmental Protection Agency that was vague. The Supreme Court ruled in favor of the Reagan administration, granting the departments of the executive branch of the U.S. government broad authority to make regulations. This authority extended to laws that were vague, both intentionally and unintentionally, with the courts deferring to the agency's expertise in interpreting unclear laws. This week, the Supreme Court reversed a 4-decade-old practice and reportedly granted the federal courts the power of interpretation. This is true when viewed from a procedural perspective. In lawsuits, the courts will become the arbiters of whether a law is vague. The reports on this ignore the court's propensity to defer, especially under the leadership of Chief Justice John Roberts, who prefers not to have the court rule of vagueness in law, but instead rule that the issue needs to be returned to the legislative and executive branches to amend the law to correct the vagueness. The critics of this ruling, stating it gives power to the court, are getting stuck in the interim phase of the judicial process. The myopic view is part of the hyperpolarized politics that exists in the United States. A simplistic perspective holds that a conservative Supreme Court ruled against the liberal Biden administration, thereby diminishing the administration's power in a political decision. However, the Biden administration opted to defend a case that the Trump administration had initiated. The conservative Reagan administration's arguments gave rise to Chevron deference. This was not a case about right-wing versus left-wing or conservative versus liberal. This was a case about the executive branch trying to accumulate more power for itself. Often perceived as a 6-3 conservative court, the Supreme Court actually consists of 3 distinct parts. The Supreme Court divides into 3 parts: 3 conservative originalists, Clarence Thomas, Samuel Alito, and Neil Gorsuch; 3 center-right moderates, Brett Kavanaugh, Amy Coney Barrett, and John Roberts; and 3 left and center-left-leaning liberals, Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson. This division in the court has resulted in a surprising number of 9-0 rulings, and pairings of the center-right and center-left in rulings are also common. The political divide often manifests in the court's decisions regarding government policies, leading to criticism of the court's voting process. The peculiar aspect of this ruling, as well as the expressed perception by the press and politicians of the Supreme Court that they are partisan and base their votes on ideology, holds some merit. Opponents of Roberts' court have employed this strategy to cast doubt on Supreme Court rulings. The press this week is reporting that the 6 conservatives voted against the Biden administration, and this appears to be true. Based on the timing of the case, a deeper review reveals that the 3 liberals on the court voted in favor of President Trump's policy, while the 6 conservative moderates voted against him and against a policy previously supported by President Reagan. Therefore, one could argue that a vote-for-my-side attitude prevails in political cases, surpassing the majority of cases where ideologies clash. Despite the argument that politics was driving the decision, This was a fantastic decision for restoring balance between the three branches of government and restoring power to voters. The ruling limits bureaucrats' capacity to formulate regulations, which the administration's political ideology can influence. Congress can no longer defer its lawmaking powers to the executive branch departments. Lower courts have guidance that they are to not defer to the bureaucracy or interpret law from the bench. When writing bills and signing them into law, Congress and the President must avoid vagueness. This means that Congress must deliberate longer and be more precise when crafting laws. And this may require coordinating with experts from inside and outside the government to give their input on the legislation. Also, the executive and legislative branches will need to work together to address gaps in the law and craft new legislation. This will slow down the number of laws created by Congress, as it can no longer defer its constitutionally mandated lawmaking authority to the executive branch. Congress should also reduce its political grandstanding hearings in order to allocate more time to crafting effective laws. Yes, this decision will make the government function much slower and more deliberative, as the legislative process needs to put expert input at the beginning of the process as law, instead of at the end as regulations determined by an executive branch agency. The laws will also be clear and concise, and not subject to the political whims of whatever administration is in power. This end to Chevron Deference could slow down the U.S. Congress, allowing the states to fill the gap and create laws based on their local determination. This would also push the lawmaking process closer to the citizenry. This is a win for the democratic process, as the ruling will not increase the power of the court, but shift responsibility back to the legislative branch. In certain cases, an activist judge may rule in favor of a political ideology, but this decision ensures that any such ruling will lose on appeal. This will undoubtedly cause unrest within the executive and legislative branches, as they will need to collaborate in enacting new laws or amending existing ones. This will give the executive branch's agencies a clear direction and subject their operations to the rule of law.